Hello, everyone. This is Tom Fox bringing to you episode 12 of the FCPA Compliance and Ethics Report. Today, I'm extraordinarily pleased to have two colleagues with me, Bill Athanas and David Simon. Bill, David, and I engaged in a tripartite debate on my blog site about the implementation of an affirmative defense under the FCPA, which we call a compliance defense. And I thought it would be a lot of fun if the three of us could get together on a call and podcast rather, and see if we could articulate our positions, but more importantly, and probably more fun for the lawyers here, to test each other's hypothesis, ask each other some direct questions, which we were not able to do in writing. So with that, what we're going to do is I come at this from in-house corporate perspective on why I don't think compliance defense is a good idea. David comes at this angle from, or comes to this at the angle from a white-collar defense practitioner, and he advocates a compliance defense, and he can certainly articulate the reasons why he thinks it's a good idea. And Bill kind of slides in as a former DOJ-er who, although currently a white-collar defense practitioner, I asked him to give us his thoughts as a former Department of Justice attorney. So hopefully between the three of us, we'll be able to articulate most of the pro and con reasons for compliance defense, and that you'll be able to hear us, understand us, and think about those, and think about how those might affect you going forward in your business, whether you're a private practitioner like the three of us, whether you're in-house counsel, or you're perhaps others. So I'm going to start off. Once again, I'm Tom Fox, and I'm a former in-house lawyer. And the real reasons I don't think a compliance defense would be a benefit to a corporation is I don't think a compliance defense would help companies because they won't go to trial. I don't think companies should go to trial in FCPA cases. If companies do go to trial, they run the risk of really pissing off juries if they've engaged in bribery and corruption, and having juries significantly spank them. Now, I recognize that if you're a white-collar defense practitioner, indeed if you're a trial lawyer, period, if you're not willing to take on a corporate client in front of a jury, you're really not a trial lawyer, and that's the role of a trial lawyer. Nevertheless, the role of a corporation is not to go to trial. The role of a corporation, as in most businesses, if it's a for-profit business, is to make money. And to make money, I think it's important that a corporation have certainty. One thing I learned in 20 years of trying cases is once you turn the final decision over to a trier of fact who is not yourself, you have lost certainty. That whether that trier of fact is a judge, whether it's a jury, whether it's an administrative law judge, whether it's an arbitrator, whoever it may be. And if a company settles a case, does not go to trial, I think that they obtain certainty. They obtain certainty in their fines and penalties. They obtain certainty in their obligations under deferred prosecution agreement, a non-prosecution agreement, or some other arrangement or settlement they make with the government. And once a corporation has certainty, they can reserve money, they can take remedial steps, they can engage in other actions so that they can comply with the obligations set forth in writing. But there's another reason that really may speak a little bit more to the psychic nature of in-house counsel, and that's the Arthur Andersen effect. For those of you who don't know, Arthur Andersen was the auditor for Enron, energy corporation here in Houston that no longer exists. Arthur Andersen no longer exists. Arthur Andersen was taken to trial by the government for destruction of documents around its auditing of Enron. Arthur Andersen made the decision to go to trial. They lost at trial. Now, they had that verdict eventually overturned, but by then it was too late. Arthur Andersen went out of existence. And I think that weighs heavily on corporate counsel's minds. You do not want to be the first corporate counsel to test the hypothesis of whether Arthur Andersen effect is correct, go to trial and find out otherwise. It is always the safer ploy, always the safer move to settle and have your obligations with certainty. So with that, I'm going to ask David to articulate some of the reasons that he thinks a compliance defense is a positive or would be effective for both a white-collar defense practitioner such as yourself, but also a plus for a corporation.
Sure. So first, let me just briefly outline why I think a compliance defense is fair and a good idea from a public policy perspective. And then I'll respond to some of Tom's points. Number one, I think the FCPA is different and it's different because of its extraterritorial nature and the great difficulty corporations that are really trying to get things right have in ensuring that there are no violations anywhere in the world. And I just think the regime we currently have effectively imposes strict liability on companies for the acts of their employees anywhere in the world. And as anybody who's done compliance work in this area knows, you can never feel totally comfortable no matter how much training you do, no matter how much how much compliance communication and auditing and controls you impose on your operations. You can never feel totally comfortable that some employee somewhere in a distant outpost isn't paying a bribe. And so in light of that, the fact that the exposure and the liability is, I think, qualitatively different in the FCPA world, I think an affirmative defense is appropriate. And it allows, it recognizes the fact that you can have an effective compliance program, and you can devote appropriate resources to compliance, and you can do all the things right and still have a problem and still have somebody not follow it. And that, to me, is what the compliance defense is really for. It addresses that situation where you truly have done everything that you should do as a corporation and still have a problem. And if you can show that, it should be a defense to liability. A couple of thoughts just on the corporations don't and shouldn't go to trial points. I don't fundamentally disagree with what a lot of what Tom said. I guess I would note a couple of things. First, at least one corporation has gone to trial on an FCPA issue, Lindsay Manufacturing. Didn't turn out all that well for them, but they did. And to me, having a compliance defense is an affirmative good thing because it provides some incentives to challenge the government. I think one of the biggest problems we have with FCPA jurisprudence today is the fact that nobody has challenged the DOJ or SEC or their expansive interpretation of the various elements of the statute. And we're seeing a little bit of a change in that as they've gone after individuals, and of course individuals have every incentive to fight and to go to trial, and that's been a good thing. I think it's provided clarity to everybody about the meaning of the FCPA and its elements. And to me, changing the rules so that the playing field is more level, to make a fight more fair between a company and DOJ or the SEC, is a positive, and it has at least the potential effect of challenging some of some companies to challenge these charges, and to challenge them on the grounds that despite the fact that there may have been a violation, that they shouldn't have liability because their compliance program was effective. And I think that's a good thing, and I think that would be good for everybody, including those who decide not to go to trial, because the prospect of trial will impact the way these issues are analyzed. So I'll stop there and let Bill share his perspectives, and then we can probably return to some of these concepts.
Okay, thanks, David. I sort of come at this from, I guess, the middle of those 2 points, and I look at it from what I hope is a largely, if not purely, pragmatic standpoint. And my initial question when I think about this defense is, is it necessary? Is it something in the current environment that is necessary to, as you said, David, level the playing field, or resolve some sort of imbalance that exists. And I'm not able to reach the conclusion that it does. I think there is there are really two faulty premises that are working here. The one being the rogue employee, or the risk of that strict liability type situation where you have an employee in Siberia who's doing something, you can't be watching them all the times, and all of a sudden you've found yourself in an FCPA mess. I'm not aware of any of those types of cases, and certainly if they're occurring, that's a problem. But I don't know of any on any wide scale basis. I frankly don't know of any on an individual basis where we have a situation where the company has clearly undertaken good faith, substantive efforts to install a compliance program, and it has been attentive to it, and despite its best efforts, some individual or quarantine group of individuals have engaged in misconduct. And absent that, I'm not sure I really see the need for it. Furthermore, I think there actually is, moving to the second, what I think is faulty premise, which is that it's not clear what's expected here, and that a compliance defense would provide some much needed clarity about exactly what companies are supposed to do. I think that there is a wealth of information about what is expected from individual companies trying to comply with the FCPA, both in the FCPA guidance, the sentencing guidelines, enforcement actions. It seems like every other month we have one of these FCPA conferences where you have a DOJ or SEC rep or both making public comments about expectations. I mean, I think Chuck Duras has been incredibly transparent about what it is that he expects. And then on top of that, we have the very public Morgan Stanley declination, which is, I think, about 18 months old now, really laying out a roadmap for what companies are supposed to do. And I think part of the challenge is that there are never going to be any, it's not going to be possible to give specific detailed guidelines for different size companies operating in different industries in different parts of the world. And we are always going to be left with these broader categories of expectations. And I think what it boils down to is that you've got to be able to show that the company had a genuine commitment to FCPA compliance. And if you're going to be able to do that, that's your compliance defense, that you really wouldn't gain anything through the enactment of a formal compliance defense. Now, I don't think that ends the debate from my perspective, because, I think simply because the defense has no utility does not mean you shouldn't enact it. I sort of disagree with Tom here, not on the underlying rationale with respect to certainty and the unlikelihood that companies will go to trial, but I guess on the conclusion that it reaches. Companies can still have certainty. They can still settle whether there's a defense or not. If the compliance defense actually accomplished anything, I wouldn't be against it. I don't think that it does, and in fact, I think it actually creates a detriment and makes the environment more difficult, where we move from a de facto compliance defense to one that is actually reduced to being part of the statute, because I just think that's going to alter an equilibrium that, frankly, I think works pretty well right now. So that's sort of my rationale, and it's, as I said, kind of a mixed bag of both of your positions, and I come down ultimately with the conclusion that this is not something that's necessary.
Well, Bill, first of all, I just want to congratulate you, because I'm hearing a lot of Southern accent in there. So turning him is wearing off on you. We get you Yankees down here, and we turn you. So you're next, David, so watch out.
Well, the firm does have Professor Henry Higgins on retainer, so it sounds like it's paying off.
Well, David, here's a question I would pose to you. How would you present evidence to a jury that your client has an effective compliance program?
Well, and Tom, at the risk of like being a talking head on Meet the Press, I'll answer your question, but let me just say a couple things I want to say first that aren't necessarily responsive. I mean, to me, just in response to what Bill just said, I think there are cases of rogue employees. I mean, I've been involved in them where, I have an example of a client that I represented in an SEC proceeding where, they had annual FCPA training that included, the precise fact pattern that the employees, a handful of employees violated, despite having, checked off the box in their training programs. Yes, I understand, and I know this is against company policy and against the FCPA. So, I do think this happens, and I think, if you talk to your corporate clients, I think very few of them would say that they are comfortable, that they wouldn't be prosecuted if, if the government had concluded that they had an effective compliance program. And one of the questions I'm going to bounce off you guys is whether you really think, if you really think you could advise a corporate client, that they would not be charged with an FCPA violation if there was a violation, if they had an effective compliance program, because I don't think so. In terms of how you'd present the compliance program to a jury if you were trying this case, I mean, I think I think we've probably all done this before DOJ or SEC, where you spend a day going through the efforts that the company has enacted to ensure compliance. You talk about the policies, you talk about the communications, you talk about the training program. You'd put in evidence about the amount of resources spent. You would certainly need to put in evidence about how how the problem at issue happened despite the compliance efforts, and you might use an expert witness. You might hire Tom Fox to come in and talk about what best practices are, and provide opinion testimony on what the corporation did and how that compares to what it should have done. And maybe this podcast will disqualify from that engagement, Tom. But I mean, you could certainly have expert as well as factual testimony that would lay it out and show what was done was reasonable.
Well, the difficulty that I have with trying to argue that you have an effective program really turns on, if you had a violation, your program must not have been effective. Now, I realize we can bounce that back and forth, probably ad nauseum. Nevertheless, on the SEC matter you named, I'm not aware of any public prosecutions of cases against corporations, not prosecutions, I mean enforcement actions in the form of deferred prosecution agreements, where it really was a rogue employee, where it really was just a one-off. I mean, we've got the example of Morgan Stanley on the declination. Unfortunately, and we could probably all three agree, I wish we could get more information on declinations. I wish that at least the fact patterns were publicly released, but the DOJ and SEC seem to have no inclination to really give us that information right now. But from where I sit, if there was an effective compliance program, I'm aware of numerous declinations. Other than Morgan Stanley, though, I don't know of any of the fact patterns. So I can't really point to those.
I mean, I agree that that's a problem. And I think Morgan Stanley's a little, I think Morgan Stanley's of only limited use because, the fact pattern there, to me anyway, shows actions outside the scope of this guy's employment in a pretty significant way that don't really fit. And while it's helpful, I don't know that at least I don't tell my clients I think they can rely on Morgan Stanley declination to say if your compliance program is effective, you're not going to get prosecuted.
Bill, would you like to pitch any questions to David or I?
Yeah, I sort of want to follow up on that. I don't think the purpose of Morgan Stanley was to sort of create that shelter. I think Morgan Stanley coming as it, in the form it did and at the time it did, had a very clear purpose, which was to respond to some pressure that was building from the Chamber of Commerce. I think they did a very effective job of suggesting that this was a standardless statute that created all sorts of problems for companies operating overseas. And Morgan Stanley was one of the ways that the government tried to respond and beat back that pressure. I think it was helpful that right around that time you had Walmart come out as well, and that sort of took a lot of the wind out of the Chamber's sails. But I also wanted to follow up, Tom, on a point you made where you said that if you have a violation, then the program must not be effective. I would disagree with that, and I think the government makes clear that it disagrees with that. If you look at the guidance, the government itself concedes, they understand that no compliance program can ever prevent all criminal activity by a corporation's employees. And if you're in a situation where you are defending the sufficiency of your compliance efforts, you have a problem. I mean, that's the only time that's going to come up. If there's not an underlying violation, you're not having that conversation. And the conduct and the efforts that you undertook are going to be looked at in hindsight. And it's in that scenario that is, as I think, as David mentioned, you want to have all those tools available. So I agree with him in that sense. What I just can't reach agreement on is that it's necessary to have a formalized compliance defense in order to do that. And I think that's probably something we're just going to have to agree to disagree on. I think, as I said, that the system works. And I guess my question would be for David, if he has seen over, let's say, the last 3 or 4 years, any evolution in dealing with enforcement attorneys, either from DOJ or SEC, about willingness to listen to good faith compliance efforts, being more receptive to those types of arguments, or whether you're finding that they're becoming more strict, or whether there's not really a change in the attitude at all.
Well, sample size is always a problem with these things, and I can't say that I've had a high enough volume to be able to discern trends. I think that enforcement authorities listen. I don't think they ignore it, and I don't think as long as I've been practicing in this area, I don't think they ever did. But I also don't think. The term meaningful credit comes up a lot more in the voluntary disclosure debate than in the compliance defense debate. But I think the government would say they give meaningful credit for effective compliance programs, and I don't think they do. I don't know if either of you have a different perspective on that, but I have a hard time concluding that. At least I see evidence of the government giving companies meaningful credit for having effective compliance programs.
Yeah, I tend to think they do if the problem is relatively discrete, but if you have a real significant FCPA problem, then they're really not. And I think the reason for that is it's tough to simultaneously argue that you have an effective compliance program if you really have a significant, borderline systemic FCPA problem. I just think those two concepts are fundamentally inconsistent. I do agree that it would be of tremendous benefit for them to give us information on declinations, and I frankly have never really understood the rationale for not releasing that, even in a completely stripped down version, obviously not naming the the companies, but I don't think people would really care if they took out the industries or the countries where it occurred. Just give us some more information that we can utilize to better advise our clients.
Yeah, I totally agree with that. Hey, Tom, can I ask you a question?
You bet.
Just on a more sort of homely basis, do you think, as someone with a corporate compliance perspective, do you think it wouldn't help corporate compliance officers in terms of dealing, with internal company politics and fight for scarce resources? Do you think that having a formal compliance defense would give those people ammunition to get more and get more attention and get more resources, and therefore have, be able to implement more effective programs?
Actually, David, my fear is it would be the opposite. That corporations would say, aha, all we have to have is these 10 points. We'll put these 10 points in place, and that's all we'll do. And all of the efforts of compliance officers and compliance practitioners to enhance anti-bribery and anti-corruption compliance in corporations really would go by the wayside, and corporations would just say, we've got a defense, we'll go to trial, and not really put the money, time, and effort into making their paper programs effective.
See, I have the sort of the opposite view, as you probably could tell from my question, and it just seems to me it's a perennial problem for compliance officers to get resources, and in the world we live in now, where you can say, well, yeah, they say they give you credit, and you might get some credit, but can't tell you exactly how much, and is it worth it to spend the several $1,000,000 that you're asking for in your budget for something that's as undefined as that? I think it would be very helpful to be able to say, look, this is real, and here it is in the law, and obviously, I don't think anybody's saying that a compliance defense would be, just checking a box of 10 elements or something like that. I think it would be clear, and communication would need to be important on that front to make it clear that it really means effective, and it's a standard that's not, I don't think anybody thinks that'd be an easily met standard. But to have it out there, I think would help, and would help, have otherwise difficult make otherwise difficult conversation with CFOs easier.
David, do you think, is there anything we could point to in terms of other statutes that are enforced against corporations or other jurisdictions where the compliance defense is a formalized defense to show, see, it works in the environmental or antitrust or fair trade context, and therefore it would also work for the FCPA? I mean, are we just talking about hypothetical concepts here?
I think we are in the. I mean, I'm not aware of anything under U.S. law. Obviously, the U.K. Bribery Act has this built in, but it's so new that we just don't have enough evidence of how it works. It's my understanding that a number of other OECD countries have compliance defenses built into their foreign bribery laws, and I just don't know what the what the track record is there. But I know we wouldn't be standing alone as a country with an affirmative defense for effective compliance if we did it. And in terms of comparing to other statutes, I mean, I think it's a reasonable objection to raise. Why is the FCPA different? And I kind of talked about that a little bit before. I think it is different because of the extraterritorial aspect of the law.
Well, but antitrust has extraterritorial jurisdiction, doesn't it?
I think to some extent, but not to the same extent. I mean, I think the foreign antitrust, international antitrust amendments. I mean, there are. I think there are more limits on the expansive jurisdictional reach in the antitrust world than in the FCPA world.
Hey, Tom, I've got a question for you.
Okay, I just need to let you know that we're really bumping up against 30 minutes, so we probably need to kind of give some final words and wrapping things up.
Okay. My question was going to be whether you think the debate is over in light of Walmart and everything that's happened.
Um, Absolutely not, as evidenced by the three of us. And there's a lot more people in the compliance community that are actively engaged in this debate, and I think it's a great debate. The one thing I didn't pick up from your article, David, that I heard you say, which may be the subject of yet another podcast, is along the lines of the following: that we really don't have a lot of case law developed under the FCPA, and so therefore we don't have judicial interpretation of the black and white letters of the law, and that having a compliance defense might allow companies to have the courage to go to trial and develop a more robust, at least FCPA jurisprudence. And I found that really interesting. Probably because of our time limits, we can't really explore that today, but once again, a very interesting point that I really hadn't garnered from your blog post. So kudos for raising that one as well. But I think the debate will continue. Let me just ask you guys both to give a final word. David, why don't you
Sure.
start?
Yeah, and thanks. This has been fun and interesting. And I have to say, despite my position that this is a good thing, in answer to Bill's question, I actually think this is likely a dead political debate for the time being, anyway. And I do think Walmart has impacted the politics of this in a way that probably means we're not going to see anything anytime soon. But I think more judicial oversight of this process and the ability to argue your case to someone other than the prosecutor is a good thing. It's how law is generally best formed in our system, in my view, especially in complex, ambiguous areas like this. And so anything that incentivizes parties to challenge the enforcers and litigate, I think would end up as a good thing.
Bill?
I guess I would sort of finish where you started, Tom, which is the reference to the Enron and Arthur Andersen case, and the memory that 28,000 Arthur Andersen employees, the large majority of which were absolutely blameless, lost their jobs as a result of the exercise of discretion by what I think were probably some pretty smart and genuinely concerned prosecutors who were worried about performing their duties. And I think the lesson we draw from that and from all of these FCPA cases we've seen over the years is that prosecutors, be they DOJ or SEC, have tremendous discretionary authority to investigate and bring these types of cases, and they can wreak havoc on a company's operations and bottom line simply by conducting that investigation, whether or not they ultimately choose to actually bring an enforcement action. And that any checks on that discretionary authority, I think, are a good thing. But I don't think that a compliance defense here accomplishes that purpose. I think it's premised on, as I said, 2 points that are simply erroneous, and that our time and efforts are better spent looking for other and better ways to improve FCPA compliance and assure appropriate enforcement of the laws, and that we simply don't need a compliance defense at this time.
And I'll just add that from my perspective, I do agree with David on the political situation currently with Walmart and other investigations that are ongoing. It's probably not going to positively impact the Chamber or anyone else's attempts to get a compliance defense appended to the FCPA. But I think that this public debate that we're engaging in and others have engaged in have moved the Department of Justice and the SEC to take action such as a Morgan Stanley declination. I think that the department, certainly I've heard Chuck DeRoss and I've heard Kara Brockmeyer from the SEC, both compliment and the ongoing debate, and I think it really keeps the regulators a little bit more on their toes. I recognize that without going to trial, they're not tested as much as they might be in a litigation format or in front of another trier of fact, whether that be a judge or jury. Nevertheless, I think the department does listen to those of us in the debate, and when we make reasoned arguments that they will either respond or somehow communicate why they believe or don't believe our arguments. So I think the debate is of value to both, certainly people like us, but I think it is of value to the compliance community. It's of value to the corporations, and at the end of the day, I think it's of value to all of our goals, all the three of our goals of greater compliance with the law, whatever that may be. So with that, I want to thank my guests, Bill Athanas from the Waller Law Firm in Birmingham and David Simon from Foley & Lardner up in Milwaukee. Gents, it's been great fun. I'm really looking forward to our next debate, and thanks again. I'm going to
Thanks for having
sign
us.
off.
Thanks, guys.